We shouldn't complain about it because it's building work, obviously, but it has been a distraction this morning, and you got the short straw because you're further away.
I will do my best. So, my lady, my lords, I finished before the short adjournment drawing your attention to Meadows and Khan and making the submission that on the basis of the Supreme Court's guidance, the question whether there is a duty of care is indistinguishable from the question, what is the scope of the duty of care? And in order to answer the scope question, one must focus on the particular harm alleged to have been caused. That's where one starts, and one then looks for.
Only if you're outside established categories.
I'm so sorry, my lord.
Only if you're outside established categories. So you don't need, if you find a snail in a ginger bottle, you don't need to start thinking about scope of.
I accept that entirely, and my submission was that precisely for that reason, Lord Hodge and Lord Sale's judgment referred at paragraph 37 to the omissions cases without disapproval as an example of how this approach has already been worked out in the authorities. We have the principles, we're not pushing at the boundaries, generally speaking, in omissions cases. So, one comes then to the question, is this an omissions case? The starting point in my submission is the particular harm alleged. You can call it fire damage, you can call it property damage, doesn't matter. It is damage caused by a third party to the property. And then one asks...
I'm sorry, so it doesn't matter whether it's fire damage or something else, it's damage caused by a third party to the property?
Yes.
Thank you.
It could be flood, it could be graffiti, it actually doesn't matter on my...
It often is.
It often is, yes. But then one looks at the conduct of the defendant which is complained of and asks, well, what part did the defendant play in the causal history of that damage? Did the defendant do something positive which had causal effect, or is it in reality that he failed to do something? Now, the appellant says, although it wasn't put this way below, that the appropriate characterisation here is that Mr. Jeffrey carried out a visit to the property. That was his activity, that was his course of conduct. And so this isn't an omissions case at all, because he was doing something positive. But of course that's just framing his conduct as one always can in an omissions case, slightly further back in the history. It's not homing in on what he did which actually had any causative potency at all. What he did with causative potency was that he failed to lock himself and his party inside the building during the inspection. If one were to say in this case that his duty was to make an inspection with reasonable care, as the appellant would have you say, that's not informative at all. It really doesn't advance the inquiry. It doesn't identify the scope of the duty in a way which embraces the harm complained of. And so it ignores the mandate now, in the light of Meadows and Khan and a Manchester Building Society, to focus on scope and harm. So the only conduct of causative potency is the failure to lock himself in. Now you can call that failure to lock other people out. That's pure semantics in my submission.
Can you also call it rendering the building insecure?
Well, my lord, if a door is unlocked, then the building is to that extent
what he did,
insecure.
is it a fair characterisation of what he did was that he rendered the building insecure.
For the time that he was inside, yes, he did. Yes. To the extent that there was an opening, may not have been the only opening, but I won't revisit that ground, an opening that wasn't there before. But what the appellant can't do is say he had a duty not to unlock the door in the first place. Of course, it doesn't say that. It can't say he had a duty not to disarm the alarm system or to leave it disarmed during his visit. Because, of course, it was essential for his visit to proceed that the alarm wasn't on. So there's no causative potency there. What matters here is that he didn't lock himself in. And that is why we say this is an omissions case, and the judge was right to find that it was an omissions case. It was something he failed to do, which amounted to the failure to prevent damage caused by a third party. And that approach is entirely consistent with the authorities. In several cases, it's been held that failure to lock a door or to secure a property, to use my Lord Justice Stuart-Smith's term, if I may, it is an omission rather than positive conduct. Perhaps I can take you quickly, because I think we've been to most of these already. Pearl and Camden at tab 2 in the authorities bundle, page 9. This was a case where the defendant, Borough Council, owned 2 adjacent properties. It failed to secure one of its properties. That enabled thieves to get into the property. They then tunnelled through the basement wall into the next and stole the plaintiff's goods. That was analysed as an omissions case. The failure to secure the property, allowing it to fall into disrepair in that case, failing to install locks, was an omission. And if you would go to its internal page 352, bundle page 19, this is Judgment of Lord Justice Oliver at G, towards the foot of the page. The defendants have, of course, done nothing. So the case is one not of an act, but of an omission. They simply omitted to keep and maintain an effective lock on the front door, giving access to number 144. And they similarly omitted to keep and maintain effective internal barriers, such as would or might have prevented trespassers obtaining access to the rear wall of the plaintiff's storeroom. It cannot be asserted that these omissions, by themselves, caused injury to anyone. They merely enabled some unknown third party over whom the defendants had no control to effect an unlawful entry upon the defendant's premises, and thence to effect an equally unlawful entry to the plaintiff's premises. So plainly, in that case, the bringing about a situation where access to a third party was enabled was counted as an omission. And the same is true in the other disused cinema case, Smith and Littlewoods. If you have that at page 62 in the judgment of speech of Lord Gough, 62 bundle page.
Page 62.
I'm so sorry, my lord, I have a wrong reference there. Well, at 62, it's an important statement, just above H. This was an unsecured, empty cinema. The lack of security enabled third parties, vandals, to get onto the property and start a fire, which caused damage. Now, the damage that it caused was to the neighbouring property. Those are the claimants, but that is not, in my submission, of key importance. What is important is the way in which the failure to secure a property was treated for the purposes of the omissions principle. It was treated as an omission.
That particular passage is a reference to the line of cases about extra hazardous activities and things like that, isn't it?
It's not. It's a reference in particular to the creation of danger exception. But more generally, Lord Gough was saying in the second sentence, I do not consider that the empty cinema could properly be described as an unusual danger in the nature of a fire hazard. In my judgment, he said, entirely justified on the evidence, fatal to any allegation that the defenders should be held liable on the ground that they negligently caused or permitted the creation of an unusual source of danger. So it's skipping ahead a little. Having decided that the omissions principle applied and that this was an omissions case, Lord Gough was considering whether the exception to the omissions rule, which applies where the defendant has created the source of danger, applied. And he was explaining there that an unsecured empty cinema is not a source of danger from fire. In the same way, if I can take on to paragraph 65, he made the same point in relation to a different kind of property damage, flood damage. Page 65, internal page 278 at B, he said, for my part, I don't think liability can be imposed on an occupier of property in negligence simply because it can be said that it is reasonably foreseeable, or even having regard, for example, to some particular temptation to thieves in adjacent premises, that it's highly likely that if he fails to keep his property locked fast, a thief may gain access to his property and thence to the adjacent premises. So to hold must presuppose that the occupier of property is under a general duty to prevent thieves from entering his property to gain access to a neighbouring property, where there's a sufficient degree of foresight that this may occur. But there's no general duty to prevent third parties from causing damage to others, even though there's a high degree of foresight that they may do so. And in the context of that, he goes on the same page at G to posit a flood example. At G, suppose, taking the example I've given of the family going away on holiday and leaving their front door unlocked, wasn't a thief but a vandal who took advantage of that fact, and that the vandal, in wrecking the flat, caused damage to the plumbing which resulted in a water leak and consequent damage to the shop below. Are the occupiers of the flat to be held liable in negligence for such damage? I do not think so, even though it may be well known that vandalism is prevalent in the neighbourhood. The reason is the same. There is no general duty to prevent third parties from causing damage to others, even though there's a high degree of foresight that this may occur. And he goes on to say, in the example I've given, it can be said that the occupiers of the flat have caused or permitted the creation of a source of danger, as in Haynes and Harwood. Haynes and Harwood is the case where the defendant left his horse and cart unattended in the street. Little boy threw a stone at the horses, they bolted and injured the plaintiff. So it's an example perhaps of how consideration of whether the omissions principle applies does shade into consideration of whether there was positive conduct which amounted to the creation of danger. But plainly, this was analysed as an omissions case, where the
Yes,
creation...
I'm sorry to interrupt.
Yes.
it happens all the time in these cases, and I quite understand why, but this wasn't analysed as an omissions case. It was analysed as a pure omissions case. And the adjective, in my view, is critical. It is a pure omissions case. In other words, all that happened in Pearl and Camden was they had a building that could be broken into. That's why it was a pure omissions case. Same with Smith and Littlewoods. But it does seem to me that's quite an important adjective, because we all know that when we talk about negligence in the ordinary run of cases, we talk about acts or omissions. The surgeon failing to stitch up the patient, he's failed to stitch up the patient, but that's negligence. It's an omission, but who cares? It is still an omission. So it is a pure omission. Both of these cases are analysed as pure omissions cases, and that's really what we're talking about. I don't want to interrupt you every time you just say omissions, but that is what we're talking about.
I'm grateful to your lordship. Of course, that's entirely right with respect, and I hope I can use shorthand because time is short.
I understand that. I understand that. But that's what we just, for the purposes of the many thousands, hundreds of thousands that are watching this on YouTube or whatever it's shown on, I think it's important to make that distinction so that they can follow the run of your argument.
I'm very grateful.
I'm not quite sure. Do you accept that Smith and Pearl are distinguishable?
I don't. To the extent that in each of those cases, omitting to do something which had the consequence of allowing a third party to access a property was characterised as an omission. And I'll also rely on them in a few moments as cases which show that allowing a third party access to a property is not a creation of danger for the purposes of the exception. Just to deal with that, my learned friend is keen to have you conclude that these cases are different because they're about how occupiers deal with their own property. An occupier can do what he wants. If he wants to leave his building unsecured, he can. But there's no suggestion in these cases that that is an important part of the reasoning. And secondly, if an owner whose property might be a source of danger to his neighbours owes no duty to secure it so as to prevent that danger arising, how can it be said that a visitor owes a more onerous duty? So there's no distinction there. And just finally, to finish off the run of cases, Top and London Country Bus, which is at page 69, tab 4 in the authorities bundle. That was a case where the bus company left a minibus unlocked, unattended, and with a key in the ignition, outside a pub. One might say, not surprisingly, it didn't stay there. A joyrider took it and killed a pedestrian. And the court found that there was no relevant duty of care. And one can see in a very short judgment of Lord Justice Dillon, with whom the other members of the court agreed, at page 71, again, the question of whether this is an omission case or whether it's a commission case because there's a creation of danger. One can see how close those questions are. At page 71 in the bundle, from F to H, Lord Justice Dillon is there saying, leaving an unsecured minibus might be thought an obvious temptation is not the creation of a danger. It's not presenting a third party with the means to commit the wrong which follows. And you'll recall that the learned Judge Below's language echoed that, because all of these cases, apart from Poole and of course Begum and the more recent Supreme Court cases, were before her, and she quotes extensively from them. All of the passages which my learned friend relies upon are quoted in her judgment. She had them in the forefront of her mind. She echoed that language in paragraph 39. Mr. Jeffrey, by not locking the door, allowed a third party to enter the premises, we must assume, but that wasn't to present the third party with the means to commit the wrong, even where it's obvious or very likely that he will do so. So, my lords, the judge was right to find that this is a pure omissions case. My learned friend says that you only have a pure omissions case where your defendant is a bystander, somebody who fails to shout out to the blind man about to cross the road, the passer-by who notices that a door to a property is standing open. If that were correct, then none of these cases that are in the bundle would have come about, because in none of these cases was the defendant a bystander in that sense. They don't tend to get sued. In every case, the defendant played some part in the chain of events which led to the damage. That's why they were sued. The question always is, was it enough of a part? Was there a close enough relationship between what the defendant failed to do and the damage which eventuated? So all of these cases, Pearl, Smith, Top, Mitchell, Michael, Poole and K.D. Karma, decision which Lord Justice Coulson gave the leading judgment, these were all analysed as pure omissions cases.
Finish your submission.
And in every single one of them, the defendant was not a bystander in the sense which my learned friend describes what he would have it as the only pure omissions case.
Can I ask you a question?
Of course, my lord.
Is Haynes and Harwood good law?
Is it good law? Well, as far as I'm aware,
it's never been overruled or criticised, as far as I'm aware.
No.
How do you reconcile it with Top, which was when Haynes and Harwood was cited in Top but not referred to in the judgment? What's the point of distinction?
The point is this, my lord, that a minibus, even with the key in the lock,
is not a horse.
Is not a horse. Throwing a stone at it is not going to make it go. A third party has to take deliberate, independent action. A little boy throwing a stone is not in the same category as somebody who gets into a minibus and drives it without proper regard for pedestrians.
Well, if that's right, then if in Haynes and Harwood, instead of a boy throwing a stone, an adult had thought he would make off with the horses and had caused the damage, the result would have been different. That sounds wrong to me.
Well, that would seem to follow from Top. Haynes and Harwood is cited again and again in the cases as an example, not so much of what is or is not a pure omissions case, but as an example of what is or is not a case where the defendant has created the source of danger, as the phrase goes. come on to that now, in fact. What one sees in the cases which explain what it is to create the source of danger, and so fall into an exception to the omissions principle, is a very close connection between what the defendant does and the harm which eventuates. Lord Gough, in Smith, describes creating a source of danger as doing something, creating a danger, which is then sparked off by a third party. The implication is that there isn't very much more for the third party to do before the risk of harm eventuates. So a little boy throws a stone at a horse. Okay? The horse is already there. It doesn't take much to frighten a horse.
So it's about a chain of causation, is it?
It is, my lady, absolutely. It is a question of not just whether the defendant played some causative role in the history of events, because they always did, otherwise there wouldn't be an issue. The question is whether that causative role was close enough to the particular harm to amount to creating the danger of that harm.
And in this case you accept, and I think you have accepted, that it's not the danger of fire as much as the danger of damage in general to the property, flood, whatever, graffiti.
Yes, it happened to be fire, and so the claimant has got to show that what Mr. Jeffrey omitted to do amounted to the creation of a danger of fire. But I'm not going to, I don't need to go that far, if I can put it that way. If the danger had been flood, if the third party had vandalised pipework at the property and led to flooding, which damaged the property, the claimant would have to show that Mr. Jeffrey had done something which created a danger of flood, which was sparked off, as it were, by the third party, had presented to the third party not just an opportunity or an occasion to commit damage of that sort, but the means to do it. So that's the sort of language which is used. That was Lord Gough's language in Pearl and Camden, page 26 in the bundle, which we saw quoted in Smith. And the reason why the learned judge was quite right here to find that Mr. Jeffrey did not create the source of danger which eventuated was simply that. He did nothing which created a risk of fire or flood, if there had been a flood, whatever other sort of property damage might have occurred. All he did was create a risk of trespass. And that is consistent with all these cases where the defendant has allowed third parties onto property who have then caused damage, whether to the property itself or to somebody else, a neighbouring property, doesn't matter in my submission. But merely giving access to a property does not amount to the creation of danger.
If this had been a contractual case, and the contract term had been to take reasonable care to prevent entry into the building, could you seriously argue that the risk that was directed to, either as a matter of contract or in tort, was simply a risk that someone might turn up and wander around? The risk inherent with intruders, I mean, I'd go further and say the risk inherent with intruders in large buildings in city centres is that they're going to set fire to the place, or they're going to pull a tap out, or they're going to do something like that. But I'm finding it really difficult to make this distinction which you seem to be making, where you just seem to stop the moment the vagrant or the intruder gets in through the front door.
My lord, I'm only stopping where the court stopped in Pearl, where the court stopped in Scott, where the court stopped in Top. And the reason perhaps is that it is easy to forget that the third party is an agent with independent volition. And this isn't novus actus. I'm not anticipating causation. This is still about scope of duty. It's the alleged connection between the conduct complained of and the harm which eventuated that we have to look at. In each case, the intervention of a third party who has only been given access is enough to take the damage outside the scope of the defendant's duty. Putting it that way sounds as if at some stage it was in the scope of the defendant's duty, but I hope it's not within the scope of a duty to keep a property secure that a third party comes onto the land and does something negligent or deliberately damaging. That's what the cases say, and the Supreme Court in Meadows and Khan did not suggest there was any difficulty. Smith was specifically mentioned. Now, my learned friend, in this context of what is required to create a danger for purposes of the exception, took you to various passages. For example, in Mitchell, Lord Justice Scott talked about the defendant playing some causative part in the chain of events which led to the damage. Also in Mitchell, Lord Roger talked about the defendant providing an opportunity for harm. And then in Robinson, Lord Reed talked about the defendant acting so as to create or increase the risk of harm. Each of those passages is quoted in the judgment below, is the first point. The judge didn't overlook those. But what the court was saying in each of those cases was not that it is enough simply to increase a risk of harm. There must be more than that for there to be the creation of a danger. For example, if I can just perhaps Lord Justice Scott's language is, if I may put it this way, that palest in Mitchell, which is at tab 8. The relevant passage is at page 191. And the learned friend took you to paragraph 40, where talking about additional features needed in omissions cases if a defendant has played some positive part in the train of events that have led to the risk of injury, a duty to take reasonable steps to avert or lessen the risk might arise. Now, if all that was required in the light of that was some involvement at some stage, then Lord Justice Scott would not have gone on at paragraph 42 on the following page, 192. To refer to the facts of that case, which were that the local authority had called a meeting with Mr. Drummond, telling him that they were going to evict him, hadn't told the claimant that they were going to have that meeting. Although it was foreseeable that after the meeting, Mr. Drummond would go out and assault the claimant, which he did and killed him. Lord Justice Scott asks in the second sentence, was this causative link, so apparently provoking the assailant, was this causative link enough, or arguably enough, to cast upon the local authority a delictual duty of care to take steps to protect Mr. Mitchell? So it is clear that some causative part is not enough. in every case one has to ask, was it enough of a causative link? And in that case, of course, it was found that there was not. If you return back in this case to paragraph 23, the judgment of Lord Hope, paragraph 23 is a very helpful collation of examples of what Lord Hope meant by creating the source of danger. Haynes and Harwood, the horses case, Attorney General of the British Virgin Islands, and Hartwell may be seen as a case of this kind. We can see the facts of that summarised at page 183. If you turn back 2 pages in the case.
That was the one of giving the man with the mental health issues the gun.
My lord, yes.
I always feel that that's not a very helpful authority because the facts are so strong that it's a bit difficult to say that, well, there's no duty of care in that. It was a bit difficult for them to argue there was no duty of care in that case.
Yes, but my lord, that's the example that Lord Hope chose as an illustration, an example of creating a source of danger, handing a gun to a police probationer who was known to be unstable.
Yeah.
So there is a very close, in these cases, there is a very close relationship between the defendant's conduct and the harm which eventuates. It's not an exclusive relationship, of course, because the third party comes in and sparks it off or carries it on, but it's close. One might almost say a direct causal relationship. By contrast, merely providing an opportunity for harm or an occasion for harm is not a direct causal relationship. Now, in the same case, Lord Roger spoke about providing opportunity for harm. And again, passage of which the learned judge was well aware.
57.
I'm grateful, my lord. Bottom page 196. And again, an example given is Attorney General in the British Virgin Islands, the gun case. But importantly, in paragraph 58, Lord Roger goes on to say, in all these situations, the defender's act which provides the opportunity for the third party to injure the claimant is itself wrongful. So in these creation of danger cases...
does that mean anything more than tortious or negligent?
Or in breach of contract. There is some wrong, because Stansby is mentioned. It's one of the few cases, it's one of the few examples, possibly the only one, where Stansby is not later analysed as an assumption of responsibility case, but a creation of danger case. But the wrong there was obviously breach of contract or concurrent duty of care in tort.
Sorry, I didn't understand. What do you get from the fact that it's got to be wrongful? That must follow, and it's the claimant's case here that not locking the door was wrongful.
Well, what I take from that is that the claimant's case is that it's actually the disabling of the protections. That's the pleaded case. That's the way it's put in the skeletons. It's the disabling of the protections. It's the removing of security from the property. That's what the claimant says is what gives rise to the duty of care. And I say, well, that can't be right because the claimant can't complain of those actions. They were permitted. The only conduct the claimant could conceivably complain of is the failure to lock himself into the property. But it's plain that when Lord Roger talks about creating an opportunity for the harm to arise, he has in mind some culpability in creation of the danger. In Robinson, which is in the second volume of the Authorities, and the third phrase, which the appellant relies upon, to suggest that not very much is required to create a danger. Paragraph 68.4, Malone and Friend took you to. It's page 370. I don't need you to read it again, but you'll remember that at the end of that paragraph, Lord Reed is describing the exceptions. Creation of danger is one of them. But he's already, in his judgment, explained what he means by creation of danger, what he means by acting so as to create or increase the risk of harm, so as to be an exception to the omissions principle. Because at paragraph 37, on page 360, he gives examples. Just above little f, halfway down paragraph 37, having quoted the pure omissions principle, he says, there are, however, circumstances in which such a duty may be owed. Mr. Forrest and Steele indicated in the passage quoted above. Excuse me. They include circumstances where the public authority has created a danger of harm which would not otherwise have existed, or has assumed a responsibility for an individual's safety on which the individual has relied. The first type of situation, creation of danger, is illustrated by the Dorset yacht case, and in relation to the police, by Attorney General of the British Islands and Hartwell, the gun case. So when, later on in his speech, Lord Reed characterises the creation of danger exception as acting so as to create or increase the risk of harm, what he has in mind is the very extreme facts of Hartwell. And for that reason, perhaps it's not surprising that the Court of Appeal in Begum said that the creation of danger exception applies only in exceptional cases. You have that, the case starts at page 506, and the relevant passage is paragraph 63 on page 522.
I'm sorry, you're going to have to give me that again. It's Authorities, tab 15, and then you were taking us to...
Page 522.
Thank you.
Paragraph 63. My Lord Justice Coulson was referring to the quartet of decisions in Hartwell, Mitchell, Michael and Robinson, as demonstrating the restricted circumstances in which a defendant will be liable in tort for damage caused by the intervention of a third party, and that it will only be in a relatively extreme case that the creation of danger exception will operate. So, my lord, my lady, playing some causative role in the chain of events which leads to the damage is not tantamount to creating a source of danger so as to take the case outside the omissions principle. Here, as I say, Mr. Jeffrey had no direct, albeit non-exclusive, causal involvement in the setting of a fire, in the commission of property damage. He merely enabled access. Following the earlier cases, enabling access, enabling trespass is not creating a danger of property damage. The learned judge was right to so find. My lords, I'll move on to the other exception, which is relied upon by the appellant in this case, the assumption of responsibility exception. Now, we included in the bundle various recent authorities which explain the concept of assumption of responsibility and the requirements for it. Williams and Natural Life, for example, NRIM and Steele. It's objected in the appellant's supplementary skeleton that these are irrelevant cases because they're about economic loss. In my submission, that is simply a misunderstanding of the nature and role in the law of negligence of assumption of responsibility. The concept is the same wherever it applies in the law of negligence. And one sees that from N and Poole. I think the most recent decision of the Supreme Court in the area of liability for omissions. That's at tab 13 in the authorities bundle. It's the case where it's alleged that the local authority had failed, negligently failed, to deploy certain statutory powers it had to remove children from housing whether they were exposed to physical injury by an abusive neighbour. Lord Reed gave judgment for the court, and he dealt with assumption of responsibility in two places. First of all, page 460. Paragraphs 66 to 68. Since those are lengthy, I wonder, might I ask you to read those for yourselves?
Certainly.
Thank you. I'm grateful. And I would, in particular, rely upon paragraph 68 at the bottom of page 460, where Lord Reed talks about an undertaking that reasonable care would be taken as to its reliability, that's the information or the advice or the service or whatever conduct is in question, either express or implied, usually from the reasonable foreseeability of the claimant's reliance upon the exercise of such care.
Isn't there a danger of confusion? This is dealing with assumption of responsibility as a way of testing whether there's a duty of care, generally, not assumption of responsibility as a particular exception to the rule against liability for pure omissions. Isn't that right?
Well, this was a case which was argued, analysed as an omissions case because...
Yeah, no, I appreciate that, but
yes.
my understanding of it, and I may be quite wrong, is that this was effectively setting up Lord Reed to say that at least one earlier decision, is it X against Bedfordshire, was wrong.
Yes.
I might have got the particular case wrong, but
That's
that was my understanding of it. I didn't understand here he was dealing with the exception against pure omissions in the sense we've been talking about it today, because obviously Headley Burn and those other cases aren't pure omissions cases. They're cases where people gave duff financial advice.
My Lord,
positively.
That's right, but in my submission, Lord Reed was addressing assumption of responsibility in the context of the law about liability for omissions, and one can see that if you would turn back to page 458, just above paragraph 60 is a reference to X and Bedfordshire, the case that you mentioned. And then in paragraph 60, Lord Reed discusses Mitchell, which is one of the omissions cases in the bundle. And just between C and D, he says it was accepted that there were particular situations where a duty of care could arise, such as where the defendant had created the source of the danger, or where the third party was under the defendant's supervision and control, here, or where the defendant had assumed a responsibility to the claimant which lay within the scope of the duty alleged.
So there, that is talking about the exception that we're concerned with today.
Yes, and also he goes on to discuss Michael, and again in the final sentence in paragraph 61, he identifies the exceptions to the pure omissions principle. One of them is an assumption of responsibility to protect the claimant, and then he goes on paragraph 63 and 64 at some length to discuss Robinson. And then from that, he immediately goes on to discuss assumption of responsibility. There is nothing to suggest that he is drawing any distinction between the concept of assumption of responsibility, which he describes paragraph 66 onwards, and assumption of responsibility as he's mentioned it only a few paragraphs earlier in the context of the omissions cases.
Okay, understand how you put that.
Now, Lord, as to what an assumption of responsibility entails, the first point, general point, is that, of course, the assumption is not responsibility to perform a task or some course of conduct or similar with reasonable skill and care. The assumption is financial responsibility to compensate the claimant if reasonable care is not taken. Secondly, contrary to what my learned friend suggested to you, reliance and foreseeability of reliance are essential ingredients. They are mentioned every single time. And perhaps one can see that most clearly in the Supreme Court's decision in NR, AM and Steele. Unfortunately, it is in the first authorities bundle, not this one. Tab 12. Oh, no, I'm so sorry. Forgive me. It is in this bundle, tab 12. That's a negligent misrepresentation case. But that is not important for these purposes. The concept is the same. And at page 396, paragraph 19, Lord Wilson, giving the judgment of the court, said what is noteworthy for present purposes is the emphasis given in the decision in the Headley-Byrne case, which of course is the ons origo of the concept, to the need for the representee reasonably to have relied on the representation and for the representor reasonably to have foreseen that he would do so. And skipping 2 sentences, if it's not reasonable for a representee to have relied on a representation and for the representor to have foreseen that he would do so, it's difficult to imagine that the latter will have assumed responsibility for it. I appreciate that that is expressed in terms appropriate for a negligent misrepresentation case, and that's not this case. But there's no suggestion in the authorities that somehow assumption of a responsibility in the omissions cases that we have in the bundles means something different from assumption of responsibility as it has been developed from the Headley-Byrne case through Henderson and Merritt and onwards. So reliance is important. And there is an essential element of reciprocity. The claimant says he happened to find out that Mr. Jeffrey was going to make an unaccompanied visit, and he said he reasonably assumed that Mr. Jeffrey would do certain things, and that that amounts to reliance. Even assuming that that is correct, that the claimant did so act, there is no allegation that Mr. Jeffrey ought reasonably to have foreseen that reliance, and that is an essential component of an assumption of responsibility. You can't assume responsibility in a vacuum, in short. There is a reciprocity that is inbuilt in the concept. And the third point, as to the meaning of assumption of responsibility, is this. Just because somebody is able to do something does not mean that they accept legal responsibility to protect a claimant from harm by doing it. That is the difference between capacity and obligation, and it's important in cases such as this one, because there is otherwise a false friend in the form of ease of precaution. Mr. Jeffrey only had to turn the snib. It would have been easy, no expense to him, no burden to him. That, in my submission, is a false friend. The fact that he had the capacity to do something, that it would have been easy for him to do it, does not mean that he had an obligation to do it. And perhaps that was emphasised in the case from the High Court of Australia, which is, this is in the first authorities bundle. I'm afraid we only have it in a Westlaw or Ostley transcript. It's a case, tab 7, where the defendant was the owner of a car park. The defendant controlled the lighting in the car park at night. Shortly after he turned the lights off one night, the claimant was assaulted in the car park. The claimant was an employee of one of the defendant's tenants. The claimant alleged that the defendant owed a duty to organise the lighting so that people working at this site, it was a shopping centre, had adequate lighting when they were going back to their cars at the end of the day in the dark. It was held that this was an omissions case, that there was no duty of care, because then specifically there was no assumption of responsibility. But in the course of that, Chief Justice Gleeson the majority at paragraph 23 drew an important distinction. That's page 126 in the bundle. He said the present is not relevantly a case of assumption of responsibility. The respondent submitted that the appellant assumed responsibility for the illumination of the car park. That submission confuses two different meanings of responsibility: capacity and obligation. The appellant owned and occupied the car park, controlled the lights in it, and decided when they would be on and when they would be off. But the relevant question is whether the appellant assumed an obligation to care for the security of persons in the position of the first respondent by protecting them from attack by third parties. So that really just underlines that, like foreseeability, like but-for causation, ease of precautions or capacity is a false friend in this area. It doesn't provide the answer to whether a duty of care exists. A great deal more is required. Well, those are the preliminary points I wanted to make before turning to the question of whether there was an assumption of responsibility in this case. In my submission, the learned judge was quite right to say that there was not. Now, the pleaded case, as I say, is very narrow. The facts relied on the alleged assumption of responsibility are that Mr. Jeffrey made an unaccompanied visit and that he unlocked the door and disarmed the alarm. So on the pleaded case, there were no relevant dealings between the parties at all. It is common ground that there were no direct dealings between the claimant and Mr. Jeffrey. It's also common ground that although Mr. Jeffrey dealt with one of the two firms of letting agents that the claimant had engaged, the letting agents gave him no instructions when they handed over the key and the alarm code. So the appellant cannot and does not allege that an assumption of responsibility arose because Mr. Jeffrey accepted the key on terms. The appellant has to argue that the mere acceptance of the key amounted to an assumption of responsibility for the security of the property. And you see throughout the appellant's skeleton arguments an equivalence drawn between having a key to the property and having possession of the property, having control of its security. My submission, the judge was right to find that just doesn't work. The first reason, in fact, is because on the claimant's own case, the letting agents who were entrusted directly with the key by the claimant didn't have a duty to safeguard the property. That's paragraph 49 of the reply, page 98 in the appeal bundle. So if the agents...
Well, what does that say?
That's...
Looking, I made the note of it, but what, you summarised it.
It says that the letting agents did not have a duty to safeguard the security of the property.
Yeah.
And yet it said that Mr. Jeffrey...
So what's that? Sorry, what's that mean? Does that mean they could give the keys to a vagrant?
My lord, that's the claimant's pleaded case. So...
What's the problem of deciding these cases on the pleadings? You should not be at 3:05 on an appeal arguing about what the pleadings mean.
My lord, that's only my...
People need to have trials. You remember trials when a judge gave a judgment at the end, they made a whole load of findings. That's where this is going wrong. So what does that mean?
Well,
You just say, well, if the letting agents don't have a duty, then how come Mr. Jeffries?
Well, like that, yes. It's my first point, it's not my only point. More importantly, it's simply wrong to say that Mr. Jeffrey had possession of the property in the sense necessary to control its security, as the appellant intends. He didn't have any right to occupy the property. He had no right to exclusive occupation. Having the key to a door wouldn't impose upon him a duty, for example, to stop a vagrant that he saw getting in through a broken door, or through a window, or through some other route in this large and complex building. Even if he watched that vagrant start to make a fire, he would have no duty simply because he possessed a key to a side door to stop, to do anything, to intervene. He would then be the bystander that the appellant would have you believe is the only person who can escape liability in these sorts of circumstances.
We won't spend more time on it, but I've just looked up what that paragraph of the reply is responding to. It's your allegation of contributory negligence. I have to say I don't find it helpful in this context at all.
Well, I hear what your lordship says. My recollection was different.
You pleaded that the defence pleaded that if a duty was owed by the defendant, then it was also owed by the managing agents, and the claimant was therefore guilty of contributory negligence.
My lord, it was a reliance point. Yes, I'm sure I returned to it in contributory negligence, but originally it's a reliance point that Mr. Jeffrey could not foresee that the claimant was relying upon him, because it had two firms of letting agents with whom it had contracts and direct dealings.
Well, I won't irritate my Lord Lord Justice Coulson any further by debating the terms of your pleadings.
My Lord, the appellant inevitably has to rely heavily upon Stansby and Truman because it's the only case that it's been able to find where a defendant was held liable for causing damage to the claimant's property, interestingly. There was liability there because there was an assumption of responsibility, and that assumption of responsibility existed because there was a contract between the parties. That's been said again and again in the cases. But there's an important point of distinction in that case. The defendant there, the decorator, was not liable because after the owner left, the defendant didn't lock himself into the building. He was liable because he left the building unattended and unlocked. That's not this case. Because it's not this case, the appellant has to hang its hat on, and because there's no contract here, the appellant has to hang its hat on Lord Justice Goff's comment in Smith that a non-contractual licensee might owe the same duty. Again, the same duty would be a duty that is irrelevant in the present case. Mr. Jeffrey didn't leave the building unlocked and unattended. But all Lord Justice Goff was saying was that on suitable facts, a licensee might have assumed a responsibility to the owner to safeguard the property. He wasn't saying that every non-contractual licensee would do that. And when one thinks about what a non-contractual license is, it's very clear that a good deal more would be required for an assumption of responsibility. A non-contractual license simply means that the licensee is not a trespasser to the extent that he is permitted to use the land and for the purpose that he's permitted to use the land. He's not entrusted with possession of the land. He's not like the building contractor under a building contract who has, in an important sense, possession of the land. A contract is required to confer entitlements of that sort. So my submission, the appellant is placing far more weight on Lord Justice Gough's comment on those in that different fact situation than it can bear. Certainly, my submission, a mere contractual licensee, merely by virtue of that license, does not assume responsibility for the security of the property. That's simply too far a leap.
So
Finally,
does the existence of a duty depend upon the licensor or whoever it may be saying to the licensee as he hands over the keys, and don't forget to lock it up?
my lord, that might well suffice. If you go out, don't forget to lock it up. But there has to be something, the mere grant of a license, the mere permission to a visitor to visit.
Well, there doesn't have to be something as between those two situations. The reason I asked the question like that is that it seems to me to be an immaterial distinction, because in both cases, although you can dress it up in different language, it's perfectly obvious what's got to happen, which is here's the key, lock it up when you give it before you give me the key back. Don't compromise the security of my building.
If you go out, because that's all that Stansby is talking about.
So now the distinction is between leaving it insecure because you're outside the building and leaving it insecure because you're inside the building and aren't in sight of the door.
Well, that's the factual distinction between this case and
it's
Stansby.
two sets of facts, but it's not, to my way of thinking, distinguishable in any way at all.
Well, what one doesn't have here is anything beyond the mere possession of a key.
That may be your problem. That may be your problem.
It's not my learned friend's problem, of course, I would submit. Because how does he get from the mere possession of a key to an assumption of financial responsibility for the security of a building? My submission, he doesn't. There is some attempt in the appellant's skeleton arguments to say that Mr. Jeffrey's special skill as an architect has some bearing, means that he assumed responsibility for the security of the building on his visit. Again, in my submission, that the judge was right to reject that. It doesn't work at all. He was not deploying that skill in the service of the claimant. That is the Headley-Byrne assumption of responsibility, significance of having a special skill. There's certainly no reason anyway why an architect, as opposed to, say, a refrigeration engineer or somebody similar, should be regarded as having some special skill in relation to the security of the property, as the judge rightly found. And then Reliance, as I mentioned, it is essential. The cases say it's essential. There is no allegation that Mr. Jeffrey ought to have foreseen that the claimant would rely upon his precautions. And that is not just a pleading point. It is important. Mr. Jeffrey receives the key from two property agents, goes through the two property agents to get the key. Neither of them give him any instructions, impose any conditions on his holding of the key. Why would Mr. Jeffrey, one asks rhetorically, expect that the claimant would be relying on him to do something which the claimant's property agents were not doing, because they weren't accompanying him on the visit. I know it's alleged that on previous visits the agents had done certain things, but again, there's no knowledge, and we remember now the large and complex building, there's no allegation that Mr. Jeffrey knew the agents had done that. I apologise if these appear to be pleading points, but in my submission they're not. They are substantive gaps in the case that's presented. And the court is invited just to ignore those gaps, to fill them in, by reference perhaps to social norms. You know, it is difficult, I accept, it is difficult to accept that there was no assumption of responsibility here to keep the door closed while Mr. Jeffrey was inside. But in my submission, that's because there are social norms about closing our own and other people's doors. The law is not there to track social norms. The law is there to allocate financial responsibility, to allocate risk. In this case, who was in a position to take precautions for the security of the property? Well, the claimant, of course, because it was its own property. It could have done that in a variety of ways. One of the ways was to engage its agents on terms that they would not permit unaccompanied visits, or not permit unaccompanied visits, at least without getting an assurance and a clear understanding that certain things would be done during the inspection.
So you say, in effect, all of this turns on the fact that the agent didn't say when handing over the code for the alarm and the key, and you must make sure that whilst you're on the premises, it remains secure. If they'd said that, you would say there was an assumption of responsibility.
My lady, yes. If there had been some relevant interchange of that sort, then it could arguably amount.
That's all we're talking about. Could arguably, we don't know. Yeah.
But there's nothing, and that is very important in my submission. The learned judge was right in my submission for substantially the reasons that she gave. Just a few concluding or finishing off points, if I may. First of all, my learned friend took you inevitably to the footnote in Clark and Lindsell, which indicates that the editors, at least of that part of the chapter, don't agree with the judge in charge of the Technology and Construction Court.
I don't think you need to trouble us very much about that.
I'm grateful. Naturally, we haven't included in the bundle all the commentators who deal with it and don't make disparaging comments. In terms of bearing in mind that this is an appeal from a summary disposal, I would emphasise that there is no relevant factual dispute justifying the trial here. The appellant's identified one, it never has. Nor is there any argument that the law should be extended in some way. This is, unlike Begum, this is not a case which pushes the boundaries. The facts are entirely mundane. Begum was very special because there was, first of all, an inevitability of danger. That's said numerous times. The defendant knew that if he sent his ship to a Bangladeshi breaking yard, people would be exposed to a risk of death. And that's expressed a number of times in the judgments of my Lord Justice Coulson and Lord Justice Mayers.
Certainly speaking for myself, I don't regard this case as on the cutting edge.
I'm grateful. I'm grateful.
My lord or my lady may disagree, but that certainly is my personal view at the moment.
the other special thing, of course, that's been mentioned this morning about Begum is that the defendant had no relationship with the victim, with the claimant's husband. He had no relationship with the third party, the employer who failed to operate safe working premises. So it's very special. This case, by contrast, is on mundane facts which are amply covered by the existing authorities, by Pearl, Top, Smith, all those cases dealing with insecure property, allowing third parties access, and finding that that doesn't amount to creating a danger of property damage. So this is not a case where trial would be justified because there is some new and exciting development of the law which ought to be explored only on the finding of facts. My lady, my lords, there's just one other matter which, for housekeeping, which I ought to mention. There are a couple of typos in references in our skeleton. May I just quickly correct those for you so that they don't waste time? Our main skeleton is at page 154 in the appeal bundle. And the first correction is page 158, paragraph 12. In the fourth line, there's a reference to Robinson at 5. That should be Robinson at 69.5. It's page 370 in the authorities bundle. And there is one other, page 161, paragraph 23.
The reference to Mitchell.
My lord is ahead of me as ever. It shouldn't be a reference in the 6th line down to Mitchell at paragraph 37. It should be to paragraph 23. Unless I can assist you further, that's all I propose to say.
Thank you very much indeed, Ms Sinclair. Mr Alkington.
Thank you. Could I make some brief points in reply, unless that's going to be a waste of time?
Please do.
Who knows?
Yes.
We'll
but
embark upon a journey.
I don't want to keep my Lord Chief Justice Coulson from his booster.
No, we've got plenty of time for that. Although I might pray my blue jab in aid if you say I now embark on a detailed dissection of the pleadings.
I don't intend to do that, but I'm afraid there are 2 pleading points I want to go to. But I'll take the flak for that when we get there. Inevitably, there's a slight bittiness in reply submissions. The response was opened on the basis that this is what we need to look at as scope of duty. I mean, it won't be lost on my lady, my lords, that the scope of duty was not the way the case has been decided by the judge. Scope of duty isn't referred to anywhere in the judgment. She was asked to strike out the case on the basis that no duty was owed. Not that a duty was owed, but that somehow it didn't extend to this particular damage or the way in which this damage occurred. And as I understood it, a plank of that scope of duty defence assertion was based on the extent to which the defendants had a key or a keys, i.e. control over one door or control over the security generally. And I just want to take you to the defence in the call bundle at page 65, please. Because the case that was advanced, the arguments that were advanced about there only being one key in the defendant's possession, came as a bit of a surprise when one looks at paragraph 5.1b of the defence. Accordingly, Mr. Jeffrey contacted PSL Labs, the marketing agents, they responded they had no one available to let Mr. Jeffrey into the property, that he should collect keys from the joint managing agent CBRE. CBRE handed the keys to Mr. Jeffrey without question, without giving instructions to him other than to return the keys to them after his visit. So, defendant's pleading position is that they had the keys, plural. And if one's considering scope of duty, my Lord Justice Stuart-Smith referred to the Jolly case, which was the one about the boys on local authority land who propped up a boat because they wanted to repair it, and then it fell over and injured the plaintiff. And the House of Lords held that, well, if some property damage, if some personal injury is foreseeable, the fact that the personal injury that suffers is much more serious than might have been foreseen doesn't matter. And similarly, if it's foreseen here that there might be some damage to the property caused by someone getting into it, the fact that that damage might be much more extensive than would be expected doesn't matter. Now, those cases aren't in the bundle because to date the case hasn't been argued on a scope of duty basis or on the basis that the damage that happened was much more extensive than it would otherwise, was unforeseeably serious, something like that. But Jolly is the case that was rightly identified. And this point's also touched upon in Mitchell. If I can take the court to the Authorities Bundle 1, tab 6, tab 8. And the paragraph we've on page 182 of the bundle, paragraph 15 is a passage that's referred to in the skeleton where Lord Hope deals with foreseeability not being enough, and there's not usually a duty for pure omissions. And in paragraph 16, five lines up from the bottom of paragraph 16, he's identifying that in the standard case of a road traffic accident or something, you don't look at whether or not there's some assumption for responsibility or something. He says it's because there's a relationship of proximity between the employer and his employees and the driver and other road users. This is sufficient in law to give rise to a duty of care. The duty is created by the relationship, and the scope of the duty is determined by what in the context of that relationship is reasonably foreseeable. In such cases, this is so obvious that there's no need to ask whether it's fair or whether it's just and reasonable that the pursuer should recover damages. So again, it's making the point, you look at whether or not there's a duty and then what's within that duty. The scope of that duty in this context is reasonable foreseeability, and it's not argued that the extent, either the happening of a fire or the extent of damage caused by the fire was not reasonably foreseeable. And I rely on this passage also to rebut the argument that, well, when one is looking at a property damage case, you need to see if there is an assumption of responsibility, and to have an assumption of responsibility, you need reasonable reliance, and the defendant needs to have reasonably foreseen that reliance. If I drive my car into someone, they're not reasonably relying on me. I've just damaged their property, and they've got a claim against me. Reliance doesn't come into it.
But when you drive your car into someone, normally, Mr. Elkington, questions of omissions don't arise, and so you're not into the territory of exceptions.
Yes, but the reason it doesn't arise is because of the relationship between car users. They all owe a duty to drive, to exercise reasonable skill and care, not to cause damage to other road users, because of the relationship between road users. And so, even if it was some form of pure omission, there would be a liability.
I think the concept of pure omissions in the context of driving a car is pretty
Yes, perhaps it's a particularly bad example, Carls, because that's where it's used as an example of how unsatisfactory it is to talk about pure omissions or acts and omissions. The difference between the cases that the respondent relies on, Pearl and Camden, Smith and Littlewoods, the Australian case, those are all cases where the claim against the property owner was based on what the property owner hadn't done in relation to, had or hadn't done in relation to the property owner's own property, i.e. the defendant's own property. And that is a very different situation to where the defendant has come onto the claimant's property and interfered with it. And so there is a clear difference between them. And that difference comes back to the rationale, really, for the pure omissions rule. We're talking about the law of negligence, which regulates what people can and cannot do without exposing themselves to liability. On the whole, you're entitled to own your property and do with your property what you will, as far as the law of negligence is concerned. And you're therefore not liable if someone comes onto that land and does something which harms your neighbour. But that's an entirely different situation where the defendant comes onto the claimant's land. The defendant's not interacting with his own property, he's interacting with the claimant's property. And if you interact with the claimant's property, then the law of negligence regulates your conduct and imposes a liability if you act negligently and cause loss. One point which was made was that all the passages on which it said the appellant relies were quoted by the judge. That reminded me of one small point that I hadn't made when I was making my submissions and looking at Smith and Littlewood. And it's that's Smith and Littlewood, if I could take you to that behind tab 3. And it's the judge did quote part of what Lord Gough had to say at 272D, where she said there are special circumstances in which a defender may be held responsible. But when you come to look again at the judgment, at paragraphs 29 and 33, what she didn't do, she stopped her quotation of that section before Lord Gough said such responsibility might well be held to exist in other cases where there is no contract. For example, where a person left alone in a house has entered as licensee of the occupier. And that's obviously an important passage which isn't quoted.
We can't get into the position of saying, well, the judge didn't quote a particular bit or stop the quotation a bit early, and therefore she can't have taken it into account, because that way madness lies.
Yes, indeed. I was really responding to the submission that was made, that all the key passages on which we rely were quoted by the judge. That's not quite right. So far as reliance and property damage is concerned, as opposed to financial loss, I don't think I need to take you to it, but if I could just give you the reference in Williams and Natural Life, which is at tab 6 at page 834H. Lord Steyn makes the point that the reason why you need reliance in those economic loss cases is that if there's no reliance, then the negligence will have had no causative effect. If someone makes a misstatement to you and you don't rely on it, then his negligence in making that statement has no causative effect. So it's an essential ingredient, those economic loss cases, that there is reliance. That's completely different to property damage. If someone damages my property, it's damage and I've suffered loss, irrespective of reliance. So that's why it's dangerous to just try and say, well, let's look at what the law about economic loss is and see how that translates into property damage. A distinction was drawn in this case with the decision in Stansby on the basis that Stansby, the decorator, left the building, whereas our complaint is that Mr. Jeffrey was in the building at the relevant time. But of course, when you've got a building of this nature, there's very little difference between being somewhere deep in the bowels of the building and being outside the building. A point was made about what Lord Gough had to say about a licensee, and the point was made that, well, a licensee doesn't have full control over the building or full possession of the building. Their only rights are that they're not a trespasser to the extent that they're given a right to be there. I wouldn't disagree with that, but that makes it, that adds added significance to Lord Gough's observation that someone who's left alone as a licensee may have responsibility. Even though they haven't got full control over the building, they may have a responsibility. And the final point is another point of clarification on the pleading, and I'll make it the last point in case I have to duck as soon as I've made it, run from the court. If I could just take the court to the reply in the core bundle behind tab 6. And paragraph 12, a point was made that the managing agents, sorry, the marketing agents didn't say to lock the building.
It's just that last phrase, or had asked them to look at it.
Yes. So while that's referring to previous visits, I accept that. It's not. I wouldn't want the court to be under the impression that the defendant was never told to lock it, when there were previous visits when they were asked to lock it. Unless there's anything else I haven't covered, those are my submissions.
Thank you very much indeed. Thank you, Mr. Elkington. As you'll both be fully aware, in this court, the way in which we proceed, unless we're prepared to give an extempore judgment, and I don't think we're going to do that this evening, is that the draft is circulated in the usual way. We'd be grateful if you would restrict your comments to typographical and factual errors and not seek to try to re-argue the case in any way. And you'll also be fully aware that unless you can agree in relation to consequential matters, then we deal with those matters on paper. And it's unclear these days whether there will be a physical hand down or an electronic one, but in any event, you're not required to attend. Thank you very much indeed to both of you for a very interesting analysis of this important issue.